This video is about extension of time in a project. What is extension of time? Before we understand what is extension of time, we need to understand what is time for a project. Every project is a time-bound event that we all know by now. The time period for a project is mentioned in the contract, which is stipulated by the employer within which the project is to be completed. It may vary up to any extent, even years, depending on the type and the volume of the project. If the project is not completed within that prescribed time period of the project which is stipulated in the contract, then extension of time, which is abbreviated popularly as EOT, is required to complete the balance work of the project. Let us understand the illustration of EOT. Let us consider the case of project whose time period is 24 months as per the contract. The project is delayed before or and after the commencement of the work and not completed within the time frame of 24 months which is stipulated in the contract. Now the client and the contractor jointly agrees to a revised timeline to complete the balance work of the project. The client then awards an extension of time to the contractor. This revised timeline is called the extended timeline. Now let us understand why projects are delayed. The time frame of a contract is stipulated at the bid stage of the contract, and all the bidders, including the successful one, must agree to that to qualify for that contract. According to the time frame, the bidder, who is the contractor, prepares a plan to execute. This plan generally considers the ideal conditions given in the contract, with some considerations for the odds which may happen during the contract period. Now, it is not possible always to envisage and assess all the problems which can arise at a later stage, which hampers for the progress of the work. The project may be 24 months, 36 months, or maybe more than that in some cases. So, at the bid stage, it is not possible always to assess what are the problems, what are the odds which will happen during the tenure of the contract, which is even years in some cases. The general reasons for delay in work are the delay in handing over of the work site to the contractor by the employer due to many issues, including the land acquisition issues, delay in obtaining the statutory licensing and government approvals for the project, delayed release of the construction drawings by which the architects and structural design engineers make a delay to the project, delay in the procurement of the required materials by the contractor, cessation or delay in manufacturing of the important materials by the approved manufacturers. In every contract, for production of certain major items, major equipments, there are certain approved manufacturers which are listed in the contract. But in case some of them stops or cease the manufacturing of those important materials, then it is not possible to bring those materials at the project right on the right time. Another reason for which delay happens in a construction work is the delay in transportation of materials due to different reasons. Delay due to force majeure reasons. Force majeure means unprecedented natural calamities like tsunami, like flood, or earthquake, or unrest or riots, war, or pandemic situations. Delayed payment released by the employers to the contractors is another reason for which the construction work delays in a project. Unavailability of sufficient skilled manpower, which is a prominent problem across the construction projects. Poorly planned completion schedules, which in which the realistic work methodology for tasks and are not considered, and thereby under consideration of resources happen. Also, sometimes the employer adds a lot of scope in the contract after the commencement of the project, which also delays the completion date of the project. Now we will understand the extension of time with a flowchart. Project is announced with a stipulated time frame. Then the bidders plan to complete within the time frame. Next is the project awarded to the lowest price bidders. During the course of the project, unprecedented delays happen, and as a result, the project is not completed within the stipulated time frame. Contractor estimates the time extension and applies to the employer for EOT. The delay accountability is assessed and agreed by both the employer and the contractor, and thus the extension of time is finalized. Let us understand what is delay accountability. Delay accountability is deciding the party responsible for the delay happened in a project. Contractors are responsible for the delays pertaining to delay in mobilizing important resources for completing the project, poor planning, etc., while the employers are responsible for delays in handing over of the work site to the contractors, issue of deliverables, as example drawings, decisions, and government approvals, etc., for which the employer is responsible on time, and releasing the payment to the contractors on time. Neither of the parties are accountable for delays happened due to the force majeure events, changes in the government policies, or international laws. Major types of delay by the contractor are poor planning for execution, resulting in non-timely engagement of resources, improper or unrealistic methodology, wrong selection of resources, and under-considering of resources. Irregularity in the delivery of resources at site, which is a supply chain failure, unable to mobilize required skilled workforce, and delay in release of drawings by contractors or consultants engaged by them in case of an EPC project. Construction error and rectification also accounts to the delay in a construction project. For an employer, the delay in handing over of the work front to the contractor on time, delay in obtaining the approvals from the local bodies or government authorities for which the employer is responsible as per the contract, irregularity in release of interim payment to the contractor, delay in engaging the consultants or architects, delay in release of drawings and decisions by employer or the consultants or architects engaged by them, construction error and rectification arising out of faulty drawings or decisions given by the employer or an consultant or architect engaged by them. Apart from the delay for which the contractor or the employer is responsible, there is a third type of delay in a construction project, which is due to the other factors like force majeure, change in the government policies, law of the land, or international law. These include natural calamities like flood, tsunami, cyclone, earthquakes, etc., war, people unrest or revolution, riot, epidemic or pandemic outbreak, change in the government policies like change in taxation or certain approval related issues, and change in the law of the land or international law. Let us understand now the implications of delay in a contract. Inevitably, the cost of the contractor goes upward if they have to stay for a longer period in a contract due to any kind of delay. The contractor is not eligible for claiming any cost compensation for any delay which is attributable to the contractor. The employer may or may not charge liquidated damage as per the applicable contract term. The time extension is awarded to the contractor to complete the balance work, but they are not entitled for claiming any cost compensation for the delay arisen for any fault of the contractor. For the delay which is done by the employer, the contractor is eligible for claiming the cost compensation due to the delay happened. Employer cannot charge the liquidated damage or any other kind of penalty to the contractor in case of the delay done by the employer. The time extension is awarded to the contractor to complete the balance work. The additional cost arising out of this extended stay, which is incurred by them, should be decided and paid. Now, for the third kind of delay, which is done by the other factors like force majeure, change in the government policies, or change in the law, the time extension is awarded to the contractor to complete the balance work. Contractor will not have the right to get cost compensation if it is not explicitly mentioned in the contract. Employer will not be able to charge liquidated damage to the contractor. In these kind of cases, generally the contractor and client arrives at a solution to share the additional cost. What can the employer do to avoid any kind of delay in a construction project? They can make the work front available to the contractor on time, arrange for all the permissions and licenses from the relevant government departments before commencement of the project for which the employer is responsible, arrange to issue all the drawings and decisions if it is in the scope of the employer on time for the contractor, arrange to pay the contractor as per the terms of the contract without any delay so that the contractor can arrange for the resources on time. They can finalize the master schedule before starting the project and monitor the resource mobilization or work progress minutely with the stakeholders and do necessary follow-up with the concerned. Now, what can the contractor do to avoid any delay in a project? They should prepare the master schedule with minute details. They should adopt the correct methodology and consider the right quantities of the resources and doesn't underplan it. They mobilize all the resources on time as per the requirement of the master schedule. Mobilizes sufficient skilled manpower and staff at site as per requirement. Notifies all the stakeholders for any input required to achieve the desired progress always. Remains vigilant for safety of the workplace and workmen always to avoid any accident. And last but not the least, they observe the required quality of the work at site to avoid any kind of rework or rectification work, which is also a major reason for delay in a project. Let us now study the impact of EOT on the cost of the contract. EOT means staying in the contract for a longer duration. So the overhead of the contractor naturally increases, thereby the cost of the construction is also increased if the cost increase in overhead is more than the contingency cost considered by the contractor in their tender budget. Now the employer also loses on the revenue generation from the project. So what need to be done by the parties? First thing, establishing a delay and granting EOT by the employer does not entitle the contractor for compensation of cost by default. To get the cost compensation from the employer, the contractor must establish that the delay is not attributable to the contractor. To establish the reasons of delay, the reasons are to be recorded by both the parties jointly since the commencement of the contract, so that no dispute is arised out of these at a later date. Every details of the delay events must be recorded so that the responsibility of the delay can be easily determined at a later stage. Here is a sample format of delay register which is required for extension of time. In the first column, the serial number, next is the nature of the hindrance. In the first instance, the delay in issue of drawing of plinth beam of certain building. Item of the works which could not be executed on account of this hindrance are all the works of plinth beam, and naturally if the plinth beam cannot be done, then the entire superstructure above it is also delayed. So we have mentioned the date of start of hindrance, which is 10th April 21, and the next is the date of the removal of the hindrance, which is 19th April 21. So here the delay in days is 10 days. Similarly, two other examples are also given, which is delay in the approval of tile sample and delay due to unavailability of cement at site. And we have shown how to record a delay with the start date and finish date and the delay in days. These kind of formats ideally should be signed by both the contractors and the employer or PMC. In case the party who records it signs it and the other party who doesn't sign, then it should be recorded over email or letters with a scanned or printed copy of the same. The above delays are to be incorporated in the master schedule to determine the delay happened in the totality and also to segregate the delay accountability of the employer and the contractor. Generally, the delay due to the contractor is not considered while preparing the impacted schedule as described above, and thereby it is not considered for extension of time. Thank you.